The case I'm going to talk about is the eternal Bliss. Sorry, first, can you see my screen, all of you, first of all? Okay. Yeah, I'm going to talk about the eternal Bliss. It's a recent decision in the High Court in London, handed down on the 7th of September. And it is an extremely important one, as Punit has said, because it decides basically an uncertainty, or it goes along the road of getting certainty on an issue that in English law has been undecided for about 90 years. So it's a very good start and a very good judgment to have in that respect. I would encourage everybody to read it if you're interested in demurrage, which is what it's concerned about, because it is a great read, and also because it obviously is a very important judgment. It's not a short judgment, it's a long one, because the judge is dealing with such a fundamental issue, but that makes it a fun read as well. Okay, well, let's crack on with the facts. First of all, it's a very simple situation, which we see pretty much daily. It was a soybean transport from Brazil to China. The vessel arrived, but there was port congestion and no available onshore storage. So there was a 31-day delay at the Chinese port before discharge. And lo and behold, upon discharge, the cargo was found to be damaged. So what happened then is what normally happens. The cargo receiver arrested the ship and demanded security for its claim against the owner. And that security responded to a judgment of the Chinese court. The owner didn't fancy his chances in the Chinese court, so he managed to settle the claim for $1.1 million US, which was assumed to be a reasonable amount for the sake of this case. And another assumption for the sake of this case was also that the cargo damage happened only because there was delay in discharge. Now, this is very important because that eliminates all kind of arguments about reasonableness, mitigation, causation, and so forth, because the parties simply wanted the judge to decide the point about demurrage that he did decide. Okay, so on these facts, it's quite obvious that there's only one breach that has occurred under the charter party, and that is the breach to discharge within the laytime. And the question the judge had to decide was, in that situation, under English law, what damages is an owner entitled to? Is he limited to have only the demurrage rate as his sole damage? Or is he also entitled to other damage for other heads of loss? For example, in this case, the cargo claim loss. So obviously quite a lot rode on the decision because it was a $1.1 million claim for cargo loss. To put it another way, the decision is really about what a demurrage rate covers. What does demurrage rates mean? What is it they're designed to cover in the charter party? Now, if you take the view that the demurrage rate is, of course, assessed by reference to the prevailing market rate for a vessel for its use in the market, so to speak, as a freight-earning asset, then should the demurrage rate be liquidated damages only for that type of loss? The loss of use in the market, because that is what it is assessed by reference to, or should it more generally be a liquidated damages clause dealing with all types of losses arising from the specific breach of the failure to discharge within the laytime? That's a fundamental question to be answered. Okay, now under English law, for those of you who are legally trained, you will know that the demurrage clause is a liquidated damages clause. And on top of that, English law says that liquidated damages clauses basically are the parties' agreements to what the damages will be for the breach of a particular clause. And on that basis, you would argue that the second limb here would be the right answer. Doctrinally, possibly it would be. However, Justice Baker, who was the judge in this case, said that there was always a but, right? There's a question of construction involved here. What would a reasonable person standing in the party's shoes, in this case, the owner and the charterer, when negotiating their charter party, what would the reasonable person standing in those parties' shoes understand demurrage to actually mean? Well, the judge said there is a general market understanding that demurrage is liquidated damages for detention. So the question then becomes, well, what would a reasonable person understand detention to mean? Is detention a type of loss, i.e. the fact that you are detained, you're detaining the vessel and therefore you're not able to use it to earn freight on the market? Or is detention a type of breach, which would be the second limb I just referred to? That was a fundamental question. And what Baker J said was that English law certainly classifies demurrage clauses as liquidated damages for breach of contract, but that does not mean that a demurrage rate is intended to be more than an agreed measure for the value of the ship's lost time. He said it does not mean it needs to be more than loss of use. He said it would not occur to commercial parties that agreeing a demurrage rate liquidated claims in respect of, for example, physical injury to ships, to cargo, as happened in internal bliss, or to crew. Rather, he said, commercial parties would understand the demurrage rate simply to compensate the owner for the detention of the ship, for the loss of use on the market as a freight earning asset, and that loss of time was not compensated by freight, and that is why demurrage was needed. So he was very much on the commercial side. He went on to say, secondly, more important or equally importantly, that if demurrage was to be construed as liquidating all the losses that arose out of breaching the duty to discharge within a certain time, then it would have the air of a partial exclusion or limitation of liability clause. And there is a prior House of Lords decision in the Swiss Atlantique that said specifically that demurrage clauses are not exclusion clauses. So Baker J, as a first instance judge, did not find himself in a position to say that to say that the second limb would be the right answer. In addition to that, he looked at all the case law that decided what demurrage is, and he said, with the sole exception of one case called the Punit, which is another first instance case we'll come across again, with the sole exception of that case, every other case where that has been decided on demurrage, the emphasis and the focus of that case has been on the nature of the loss that is resulting from the breach of the failure to discharge within the laytime, right? So it's the nature of the loss that is important. It's not the breach itself. So he said, and this is where you need a cold towel to wrap around your head potentially. He said there was a clash of logic between the two positions that English law currently had. First of all, the rule in invocip, as it's known, which is that no matter what breach there is under a charter party, if the only result of that breach is the loss of use of the vessel, then the owner's only compensation is that set out in the demurrage clause. So that says the demurrage clause relates to loss of use. Okay, it's about the loss that is incurred. That's the first proposition. The second proposition is the proposition laid down by the Punit, which says that basically without a separate breach of the charter, so unless you have two breaches, one of the duty to discharge within time and another breach, then you cannot claim any losses whatsoever apart from the demurrage clause, because there's a disconnect between these two, because the second proposition says the demurrage clause relates to the breach itself and not the nature of loss. So those two things are inconsistent. And what Baker J did in the Eternal Bliss was he resolved this tension, and he resolved it in favor of the first position, basically that the loss of use is what the demurrage rate relates to, and that if there are any other kinds of losses that result, even if there's only one breach of the charter party, i.e. the breach to discharge, then they can be claimed separately without a separate breach. So that's very important for ship owners going forward, as we will see. Now, that's what was decided. What I thought would be quite interesting, and I'm conscious of time, would be to look at how he reached that decision. This judgment is 40 pages long and 153 paragraphs long. And you don't need that much space to describe what I've just described to you as a decision. The reason why he took so long to decide this case was because he had to find a previous case had been decided wrongly. And that is no mean thing for a first instance judge to do. Okay, so I wanted to look just a little bit about what he actually decided and how he got there. He looked at three principal cases. The first one is the Punit, which I've talked about already, and that is the prior authority for the idea that you need to have two breaches, i.e. if you only have one breach of discharging within, not discharging within the late time, then you cannot claim anything apart from demurrage. That's the first case. That was decided by Potter J. The second case he had to deal with was Ryder and Arcos, and that is the fundamental case that has created the issue here. Okay, and that is a Court of Appeal case from 1926. The majority in that case held that in that case there were two breaches and the owner could claim both demurrage and dead freight. However, there was one minority judgment by Banks LJ, and this is the key. Banks LJ decided actually there was only one breach, but the owner could still claim dead freight and demurrage. So he could claim two different heads of loss, even though there was only one breach of the charter party. And that's a key factor to keep in mind. The last case he had to deal with, Baker, was Swiss Atlantique, which was also relied on by Potter in deciding the Punit case. Okay, and that's a House of Lords decision, which I'll deal with a bit later. Now, of the Bonner, Baker said, and he acknowledged that if he was going to hold in the eternal bliss in favor of the owners, he would have to decide that the prior case, the Bonner decided 30 years earlier, had been wrongly decided. And as I say, that's no mean thing. In relation to the Bonner case, Baker said that Potter J had been right to say that the majority in the Court of Appeal in Ryder and Arcos had decided that there were 2 breaches in that case. That did not mean, however, that they had decided that there had to be 2 breaches in order to make a claim for different types of loss. Okay? He said that Potter J had mistaken that. Instead, what he said was that the Court of Appeal majority did not say that they thought a different breach was required. Okay? They did not say that they thought that Banks LJ in his minority judgment was wrong in what he was saying. They simply found that in the particular case, Ryder and Arcos, there were 2 breaches. So it was unclear if they would have held, had there only been 1 breach, if they would have agreed with Banks LJ, or they would have said you couldn't recover. So that's very important to keep in mind. But Baker J said Potter J got that wrong. Baker J then went on to consider the Swiss Atlantique case from the House of Lords. Now that was a 1 breach case. The only breach was a breach of the laytime, okay? It was a case for consecutive voyages, and the owner was arguing that he missed out on some voyages because excessive breaches of laytime, or excessive demurrage. So the owner argued exactly as the owner did in the Eternal Bliss, that the charterers had only breached laytime, but the owner had suffered more loss than just demurrage because he had lost voyages, okay? Same argument was made. Baker J noted that the claim failed not because there was only 1 breach, but because the only loss that was suffered was held by the court to be detention of the vessel. And therefore, 1 breach leads to detention of the vessel. If there's detention of the vessel, that's covered by demurrage. The court does not decide that you have to have more than 1 breach, okay? So Baker J said that Potter J, who decided the Bonner, had misread, this gets a bit complicated, misread the Swiss Atlantique judgments when he was deciding the Bonner, right? And he had misread those judgments to say that Ryder and Arcos, the Court of Appeal decision from 1926, had decided that you have to have 2 breaches. As we saw, Baker J said that's not what was said in Ryder and Arcos. The Court of Appeal didn't say that at all, but Potter J insisted they did. And that was the basis for Potter J's decision in the Bonner, which Baker J then subsequently found was wrong. Anyway, in Swiss Atlantique, Baker said that the House of Lords, rather, they focused again on the type of loss that was suffered, not on the breach. And he also said that the fact that the lordships talked about the nature of demurrage did not amount to a conclusion that they thought a separate breach was necessary. Okay? He basically says that there was nothing in the Swiss Atlantique case of the House of Lords that suggested that Banks LJ's approach in Ryder and Arcos, the minority approach, was wrong, right? Okay, so they didn't say that in a 1 breach case you can't have loss of use and additional losses claimed as well. Okay, well, on the other hand, Swiss Atlantique also didn't say that you could, so it wasn't authority for the proposition. But in any case, Baker J decided that the Bonner has been wrongly decided and then went against it because of the way that Baker J interpreted the judgments in the previous cases. And that brings up a really fascinating question of whether or not he actually had authority to do what he did. Did Ryder and Arcos actually decide that you didn't need 2 breaches? Was Baker J entitled to conclude that the language used in Swiss Atlantique suggested that a type of loss was the key? And was he entitled to go against the previous decision? And these are prime factors involved in considering whether to appeal. In any case, we are where we are. And the bottom line is the decision has been made. So demurrage now means it liquidates loss of use only. So if there's any other kind of claim that's not related to loss of use, you can make that claim on top of demurrage. Okay, so for example, hull fouling would, in my view, be recoverable in addition to demurrage. Loss of a follow-on fixture, arguably not covered by demurrage, right? Damage to a ship, damage to cargo, as in the Eternal Bliss, can be recovered. Of course, always subject to causation and remoteness. Okay, and then there's an obligation to pay increased hire under a time charter. Probably not, because that is related to loss of use, right? Okay, so that's the kind of thinking or the possibilities that are involved. But Yeah, and of course the parties will start to redraft the demurrage and demurrage rates clauses, I'm sure, but I'll leave Punit and Captain Dutt to talk about that. Where we are now, there is permission to the Court of Appeal to appeal, and that will be done. Opinion remains very split, so this is certainly not the final word on the topic. Thank you. I hope that was fast enough.
Absolutely, it was very fast and well done. Thank you so much. But as I said, this case is going to generate a lot of people following up on the appeal for sure. As one of the commentaries mentioned, it's eternal bliss for owners and continuous and complete misery for charterers. So let me just try and bring up my slides on this one. Yeah. So just a quick slide. I think you've already done a lot of, you covered a lot of ground. Just a quick one. I've just got 3 slides on this, and Captain Dutt would definitely like to weigh in. The key aspects, of course, is demurrage and other related losses in a void charter. You already mentioned that. So what are the questions that the court asked? Whether in addition to paying demurrage, charterers will also liable for compensating owners for other losses, which you already mentioned with some examples, for the same breach as in failing to complete discharge within permitted lay time. And also if there was no other breach of charter, whether demurrage was the exclusive remedy for owners' losses, irrespective of the type of loss in question. So these are the kind of commercial questions which have come out, and the answers are there. You already have gone through it. I will not go through it. The only interesting thing is this last D part. The owners were entitled to demurrage for time lost and also entitled to compensation in respect of losses and expenses arising out of cargo claim. Now, what does that mean effectively for the owners? The owners are very happy. They are looking for floodgates to open. They are looking for true eternal bliss, as they say. This is like serious amount of advantages sitting with the owners. And I think in this case, it was K-Line, which obviously was the owner in this case. And Priminds was a charterer. Charters, of course, have to look at 2 aspects, at least from the commercial perspective. They have to check the current charter parties and then maybe check the sub-charters to see if they can pass down a claim like this, if a claim is brought like this from the owner. Of course, you have jurisdiction issues. People are having sub-charters in multiple jurisdictions. That can be a big challenge for sure. And that, I think, will be something that people will always remember. Now, coming to future charter parties, from a commercial perspective, it's all about commercial balance. The charterers must write in a clause if that the demurrage will cover all damages, all consequential damages. You can make it as wide as you want, but it's not going to be easy to push it down the throat of the ship owners that easily, especially now they know that this case is existing. And then the facts of the case may be highlighted and a possible way to distinguish. As you mentioned, there were already similar cases, each having a different interpretation of whether what demurrage is. So it could very easily be that you can distinguish cases from this particular case of eternal bliss. That can be one of the ways that charterers can kind of look to cover themselves. But obviously, they are in a real difficult position now if this case. And I just want to clarify this, Steffen. As it stands today, this is the law. The law is that the demurrage is basically for detention, but there is also ability for the owners to claim other losses which are resulting due to the same breach of exceeding the lay time. Yeah, correct?
Well, you have conflicting decisions now. Yeah, but yeah, you can argue it's the law now, right? Because it's the latter decision. Yeah.
Interesting.
But you will have an answer from the Court of Appeal before long, I'm sure.
I'm sure. Captain Dutt, your views. This is a very interesting case, according to me, and I'm so happy that we are talking about it. Yeah.
No, absolutely. Punit, again, you've covered the points, but it is one of those cases which leaves us a little bewildered sometimes, the outcome. So I also looked at the basic facts of the case, and the first point which is intriguing is this voyage from Tubarão to Longkou, that's South America to North China. The voyage took 48 days, which seems somewhat longer than the normal sailing time. So 48 days, and then the ship waited about 30 odd days, so it leaves you close to 80 days waiting. So how did the court and everybody else establish that the deterioration of cargo started after arrival at Longkou? That the holds were not inspected on arrival, so it could very well have started earlier. So that's something floating in the air, which should have been probably taken into consideration. Aside from that, yes, the demurrage clause is a pre-printed standard clause in the main body. So attempting to modify that now would be a challenge both for owners and charterers. So yes, I think either side, if either side tried to make a very creative wording, it wouldn't fly, because the counterparty would then would definitely object. So we'll have to wait for the of the appeal. And having said that, we have seen similar cases now with this trade wars going on between US and China, and now Australia and China. Vessels arriving with soybean from the US were not allowed to discharge. So I don't know how long they waited, So that's a good example. I think it would happen to Australian grain arriving into China as well, long and indefinite periods of waiting. So let's see how they deal with possible cargo damage, if any. So that's about it from my side.